Hey everybody, Todd Vandermite back here for another edition of Freedom Steel, former NRA contract lobbyist, Illinois gun law guru. Want to announce that we have cracked the 6,500 mark on subscribers. So to everybody that is liked, subscribed, and shared and passed us around, we really want to thank you oh so much. Another shout out to KB32. Looks like his plug is continuing to give us some dividends, as well as the guys over at T-Tag and Gun Save Life. So really want to appreciate everybody that's been passing the word out there. Today, I want to talk about a case called Friedman just a little bit because it's kind of interesting. It's popping up all over again. So Friedman was a challenge by Ari Friedman to the Highland Park semi-auto ban back in the day when they first passed it. It was a case that the NRA funded and brought, lost at the district court level, and then lost again at the Seventh Circuit Court of Appeals. And at the Court of Appeals, it got real interesting. And so it came up in the context of the Naperville case. We are certain it is going to come up in the context of the cases we have down south. And here, so in part of it, when the judge was looking at Friedman in the Naperville case, she had to decide whether or not Friedman was still good law. And in part of this, she talked about that the court did not engage in the two-part test the way she saw it, and said that the court explained that we think it better to ask whether a regulation bans weapons that were common at the time of the ratification or those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia, and whether law-abiding citizens retain adequate means of self-defense. Quoting Friedman. And the Friedman court got it completely wrong there. There were a couple of parts. There's another part where they said that they didn't have multi-shot guns back in 1791. They were all single-shot muskets. They just really got it wrong there. The part of Friedman that really sticks out was that when Justice Easterbrook said, if a ban on semi-automatic guns and large capacity magazines reduces the perceived risk from a mass shooting and makes the public feel safer as a result, that's a substantial benefit. And that's always been the thing that just really, to coin a phrase, grinds my gears when it came to Friedman. But an interesting part is that Friedman went up to the United States Supreme Court, and the court denied cert back in December of 2015. And Justice Thomas and Justice Scalia sat there and wrote a dissent from the denial. And I'm going to quote that denial to you as to why it's important. They open with, our central holding in District of Columbia v. Heller was that the Second Amendment protects a personal right to keep and bear arms for lawful purposes, most notably for self-defense within the home. All right? So right there, they said most notably. It's for lawful purposes. We've had the argument about such as that the other side wants to dissuade, that they don't want to talk about that. They want to gloss over it. They have tried to argue that Heller only applied to guns in the home and handguns at that. So with that, but here they go on, and this is quoting from the dissent for cert in the Friedman case. The city of Highland Park, Illinois bans manufacturing, selling, giving, lending, acquiring, or possessing many of the most commonly owned semi-automatic firearms, which the city branded assault weapons. All right, right there. You have the author of the Heller decision. You have the author of the New York decision calling semi-automatic firearms deemed assault weapons as in common use. They said it right there. And I would give great weight, even though this is a dissent from cert, I would give some weight to this because of who these two gentlemen are. Let's see. For instance, the ordinance criminalizes modern sporting rifles, AR-style semi-automatic rifles, which many Americans own for lawful purposes like self-defense, hunting, and target shooting. The city also prohibited large-capacity magazines, a term the city used to refer to nearly all ammunition feeding devices that accept more than 10 rounds. The city gave anyone who legally possessed an assault weapon or a large capacity magazine 60 days to move these items outside the city limits, disable them, or surrender them for destruction. Anyone who violates the ordinance can be imprisoned for up to 6 months, fined up to $1,000, or both. Petitioners, a Highland Park resident who sought to keep now prohibited firearm magazines to defend his home, and an advocacy organization brought a suit to enjoin the ordinance on the ground that it violates the Second Amendment. The District Court in Northern District of Illinois granted summary judgment to the city. A divided panel of the Seventh Circuit affirmed. The panel majority acknowledged that the prohibited weapons can be beneficial for self-defense because they are lighter than many rifles and less dangerous per shot than large caliber pistols or revolvers, and thus householders, too frightened or infirm to aim carefully, may be able to wield them more efficiently. Lawful purposes. Doesn't say they have to be used. The majority nonetheless found no constitutional problem with the ordinance. It recognized that Heller holds that the law banning the possession of handguns in the home violates the Second Amendment, but beyond Heller's rejection of banning handguns in the home, the majority believed Heller and McDonald leave matters open on the scope of the Second Amendment. The majority thus adopted a new test for gauging the constitutionality of bans on firearms. We will ask whether the regulation bans weapons that were common at the time of the ratification or those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia, and whether law-abiding citizens retain adequate means of self-defense. Just quoted part of that from Judge Kendall. Judge Mannion dissented, reasoning that both the ordinance and this court's opinion upholding it are directly at odds with the central holdings of Heller and McDonald. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. We explained in Heller and McDonald that the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. We excluded from this protection only, quote, those weapons not typically possessed by law-abiding citizens for lawful purposes. And we stress that the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. My favorite passage, that's out of page 63 in the Heller decision. Instead of adhering to our reasoning in Heller, the Seventh Circuit limited Heller to its facts and read Heller to forbid only total bans on handguns used for self-defense in the home. All other questions about the Second Amendment, the Seventh Circuit concluded, should be defined by the political process and scholarly debate. But Heller repudiates that approach. We explained in Heller that since the case represents the court's first in-depth examination of the Second Amendment, one should not expect to clarify the entire field. We caution courts against leaving the rest of the field to the legislative process. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope too broad. Again, my favorite part out of Heller. Based on the crab reading of Heller, the Seventh Circuit felt free to adopt a test for assessing firearm bans that eviscerates many of the protections recognized in Heller and McDonald. The court asked in the first instance whether the banned firearms were common at the time of the ratification, but we said in Heller that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. The Seventh Circuit alternatively asked whether the banned firearms relate to the preservation of an efficient or well-regulated militia. The court concluded state and local ordinances never run afoul of that objective, since states, which are in charge of militias, should be allowed to decide when civilians can possess military-grade firearms. But that ignores Heller's fundamental premise. The right to keep and bear arms is an independent individual right. Its scope is defined not by what the militia needs, but by what private citizens commonly possess. Moreover, the Seventh Circuit endorsed the view of the militia that Heller rejected. We explain this is just so much where Justice Scalia and the principal author of New York, Justice Thomas, were in sync on this. And they laid down the law. And that's why this dissent from cert should be given, in my mind, some great weight. Because even though Justice Scalia is no longer with us, you know what he was thinking. Back in 2015, he said ARs and semi-automatic rifles were commonly owned. Lastly, the Seventh Circuit considered whether law-abiding citizens retain adequate means of self-defense, and reasoned that the city's ban was permissible because criminals can find substitutes for banned assault weapons, and so can law-abiding homeowners. And they go on to just criticize the Friedman decision. You've had it criticized by courts down in the Southern District of Illinois. Justice Gilbert's mentioned it back in the day, or back when we reviewed some things on him about whether or not we thought he would be a good judge or whatever. But here, the two justices that wrote the two quintessential opinions on the Second Amendment have come out. And they go on to assault that feelings portion. The Seventh Circuit ultimately upheld a ban on many common semi-automatic firearms based on speculation about the law's potential policy benefits. The court conceded that handguns, not assault weapons, are responsible for the vast majority of gun violence in the United States. Still, the court concluded the ordinance may increase the public sense of safety, which alone is a substantial benefit. Heller, forbids subjecting the Second Amendment's core protection to a freestanding interest-balancing approach. This case illustrates why, if a broad ban on firearms can be upheld based on conjecture that the public might feel safer, then the Second Amendment guarantees nothing. That's it. You have the two quintessential authors of 2A opinions at the Supreme Court. Yes, Justice Alito wrote McDonald, but if you pile on Quintero, where Justice Alito, in a concurring opinion, said that stun guns at 200,000 were in common use. Now, everybody thinks you can just staple Heller or New York to a complaint and that's it, game over, but it's not. But this is why. I think that the state is going to have a tough time. The state will probably argue Friedman is still good law, but this alone. Now, this is only two justices. This was not a majority of 5 because they didn't take the case up. And we had heard back in the day that Justice Alito was leery of taking up any case where he didn't think they would guarantee the 5 votes. And back at this time, you had Kennedy on the court, and even if you were carrying Roberts, that was only 4. But I think this is going to be illustrative of the arguments we have to clarify, quote, and why we should probably, on our side, be building a battery of amici and apportion out amici subjects around a various number of issues. You've got weapons of war. You've got this new thing about wounds you see on the battlefield. You've got all kinds of in common use. You could sit there and have a dozen or more amici briefs, David Kopel could do one on the knife stuff alone, just to tear down every single argument that these guys have, point blank, with all that. But Friedman, Justice Kendall recognized was not good law anymore, that it had been overturned by New York, and then went back in and found another way to resurrect virtually everything Friedman stood for except feelings, as if this was Michael Myers in a Halloween movie or Jason out of Friday the 13th. So it's an important thing that I think we need to keep in mind, and it's how we need to argue some of this stuff in front of the courts. And we need to make sure that this information gets in briefs in front of the courts so they are well aware of this. Now, one of the few things I'll say out of the Naperville decision is they recognize Friedman's dead letter law. It'll just be interesting to see what the Attorney General's office files and how often they cite Friedman in just 10 days when their briefs are due in front of the court. And we'll find out a little bit more about what they argue when we have a status conference on Friday with the 4 downstate court cases. So with that, as always, guys, thank you very much. Hope you enjoyed this little throwback in time here. So, guys, thanks again. And remember that this litigation we're involved in is expensive, and we're going to have the links below for you guys to donate to. We really appreciate that. All the money is going into the litigation fund. It's helping get whatever we need done. We've got 2 sets of attorneys with Michelle and Associates out in California, the guys that are handling the Duncan case and the Rhodey case and a couple others, and we've got our local counsels here, Shaw and Danforth. And it all costs money to do that. So whatever you guys can donate to the links below, we really appreciate that. Thank you very much. And as always, please like, subscribe, smash that notification bell for us. Copy and paste this, share this around on all your social media contacts, blogs, forums, things like that, and help get the word out. We really appreciate you getting us past the 6,500 mark on to 7,500, and then we're going to try to break 10,000 here before too long. And as always, frag out.